Okay, good afternoon. My name is Patrick Williams. I'm the manager for fair housing for the Texas Workforce Commission Civil Rights Division. First, I want to take this opportunity to thank you all for allowing us to participate in this event this afternoon. For the past 18 months, the Civil Rights Division has taken a lot more concerted effort to conduct outreach events. We've always provided training to FIPS and other types of organizations on fair housing. A lot of that was mainly to respondents after a conciliation agreement that required training, or in conjunction with Fair Housing Initiative program, training those citizens out there in the state of Texas. But these outreach events were important to us, taking a model from what you'd call community policing or engagement in the military, just to get out and talk to customers. And we've been doing that. And we from our point of view, we've partnered with the apartment associations across the state of Texas, municipalities, as well as at the state appraisal board. And all those associations have been important to what our business is. And our business in CRD is kind of twofold. The mission is enforcement, in this case, fair housing, as well as training and education. There's no way that we can enforce our way out of this business. As long as you have the human factor, the human equation, people are going to do what people do. Mistakes will be made, no matter how much education you provide. But when you've done the right thing and provided education and those mistakes are made, there's just not a whole lot more you can do. Well, today, Mr. Jeffrey Riddle, who's our primary trainer for CRD for both employment and fair housing, will take you through basically Fair Housing 101. And then also with me today is Mr. Joe Rosser, who is one of our supervisors of investigation, as well as Mr. David Purnell, another supervisor of investigation. And they'll provide you with a couple case studies, and then we'll talk a little bit about reasonable accommodations, because I think your association has about 10% of its members actually are in the property management. So with that, I'll go ahead and turn it over to Mr. Riddle to do the presentation. Jeff?
All right. Thank you, Pat. All right. Well, getting started, as you said, we are going to be covering the breadth and scope of Housing 101. So we're going to be covering a lot of different subjects. So please bear with me on this. I will hopefully not try to make it as confusing as possible, but we're going to hit a lot of different fun areas. It's important to note, Pat already kind of mentioned, we are the Civil Rights Division, and we do have that jurisdiction, that enforcement of those state and federal policies across the entire state of Texas. Everywhere from wherever in the Panhandle. I've been to Dumas this year. If anybody knows where Dumas is at or has been in the Dumas area, it's like an hour north of Amarillo down to Harlingen in the Valley, El Paso to Longview. So a lot of windshield time. We get to cover the entire state. I get to see the entire state, which is always a very fun time. So we are that agency within the state of Texas that has that enforcement, as Pat said, of housing rights. And it's important to note that the basis for everything that we talk about today is actually coming out of, it's going to come out of a lot of different laws. The main proponent one in the state of Texas is the Texas Fair Housing Act. It was signed in 1989. It is substantially equivalent to the Federal Fair Housing Act that was signed in 1968. They are the same. Verbiage is the same. There's not anywhere that we're going to talk about today except for one specific area. And I will highlight that one area. You don't have to worry about me slipping it in and you not knowing where it was at, where state and federal law are the same. So we're not going to make any major distinctions except for in one area. The state of Texas has added some additional protections here late, actually rather recently. But everywhere else, we don't need to try to figure out what is state law and what's a federal law. They are substantially equivalent. So what is covered under the whole umbrella of fair housing? the biggest one is rent sale terms and conditions. I say the biggest one. This generates a lot of the business that we do. This is where somebody is trying to negotiate for a house and there's a refusal. There is a refusal to rent or lease a home, denying of a unit, setting different kind of terms and conditions. Failure to accommodate, which, as Pat said earlier, we will get into that conversation as well. But rent sale terms and conditions is, when we think of fair housing, it is the most prevalent thing that we think about, but it is not the only thing that fair housing covers. Fair housing also covers publication. And that is that you can't make, print, or publish a statement about the sale or rental of a unit that could indicate any kind of discrimination. And it could be, I don't mean to discriminate, I just say I specialize in lending to a protected category. I specialize in Christian lending, but that could run afoul of the religious protected category. So we always have to be careful when we make and publish those statements wherever that publishes. I mean, we're not going to publish it officially in a newspaper probably much anymore. It is probably more in the online arena, but that is part of this as well. Brokerage services. Based on who we're talking today. I don't get a lot of times. Most of the time I'm dealing with property management people. So it's really fun that I get to highlight this one and it actually means something. So yes, brokerage services are covered under the Fair Housing Act. Having access to different lists or being denied MLS listings or having only able to access it in certain geographical areas. That is all covered under the Fair Housing Act as well. And then we have our loans and financial assistance. Unfortunately, this law does not protect people from getting that new Ford EV Mustang at a 24% interest rate. It's not that kind of loans and financial assistance. This is specifically, of course, obviously dealing with housing, but it could be any type of determination of a loan, interest rates, down payments, where that decision is not being based in credit reports or income. Nope, that is being based in somebody's protected category. If a loan or financial assistance decision is being based in somebody's protected category, that is against the fair housing laws. And then what goes against everything that we just talked about? The biggest one is discrimination. So discrimination is differential treatment of somebody, again, based in their protected category. Everybody belongs to at least 5 of these 7 protected categories when we talk about housing. 2 of them do have some couldn't get that word out, specific requirements to meet, but everybody else belongs to 5 of the 7. You might belong to all 7. Some people do. You might belong to 6 of 7 or only 5 of 7, but that is all who we are. And if we treat somebody differently, and it doesn't matter if it is a small, almost inconsequential treatment, or if it is a big major treatment. If I'm just not going to give this person the maintenance request that they want in a timely manner because of a protected category, something pretty small and minor maybe at the time, or just outright denying selling a home to somebody, that is differential treatment if that differential treatment is, again, based in somebody's protected category. The other thing that does run afoul of the fair housing laws is retaliation, interference, coercion, or intimidation. You cannot threaten, intimidate, or interfere with somebody based in their enjoyment of a dwelling based on their protected category. You can't threaten to take adverse action based on that protected class of the housing consumer. And you cannot retaliate. You cannot impose new restrictions because somebody has filed a fair housing complaint on their broker or their housing provider. We cannot treat them differently because they filed that complaint. If we are still making business-related decisions, again, based on business-related practices not related to a protected class, there still could be a perception. So it is important to make sure that everything is documented, because it's not saying you can't, if there is a fair housing complaint, that you still can't take action. It just cannot be because that person has filed a complaint. And then it is important to note when we talk about unlawful practices, the discriminatory effects doctrine. If you've been in the fair housing arena for a while, has come back into practice. It went away for a little bit and changed a little bit, and now it has come back into the full discriminatory effects. It does include disparate impact and perpetuations of segregation, is what this is. And what the discriminatory effects, it is a HUD policy. So it's not law, but it is a policy by Housing and Urban Development, obviously federal level, in that they are looking at policies, procedures that could have a detrimental effect on disproportionate populations based in protected categories. And what they would try to look at is if you could still have the same effect. Like, I have this policy, and this is why I have this policy, because we all set policies for a reason. I have a policy, and it is for this reason. But if there's another way to apply that so not as many people could be excluded from those services, then we should do that. For instance, if I have a policy where anybody with a Class C misdemeanor arrest is not able to rent from me, and I'm doing that because I'm trying to protect all my other residents from a potential criminal element. Could I still have that same effect if I changed my policy to anybody with a Class C conviction, where you see where that change from arrest to conviction could open the door for more people to do it, where I'm still getting the same effect out of it. So that is what the discriminatory effects doctrine is looking at, is those policies that could be altered to allow more people to partake in any part of fair housing with the same effect of still protecting what it is those policies or procedures were there to do. And then a common thread that is going to interweave through a lot of what we talk about is going to be the idea of intent versus impact. It's important to understand, bottom line up front, the intention doesn't matter. We always need to focus on the impact of the site. And I say that because a lot of times people will try to minimize the impact or explain away the impact by justifying the intention or explaining the intention. I could have grown up in a different day and age, and I don't believe that women should be as a highest statute as men. The only person that could apply for it should be a man. And if somebody is trying to focus on my intention, well, Jeff grew up in a different day and age, just the way he is, just bear with them. That is trying to minimize the impact by explaining away the intention. But the bottom line is, I'm still being discriminatory against a person based on their gender. So we always have to look at things from an impact perspective, not an intention. Having it be a joke or somebody was that's just the way they are, do not absolve the fact that discrimination or harassment occurred. All right, so I was hyping them up enough. I said earlier, I know everybody's thinking there were 7 protected categories, because I was going to ask, but there are 7. We have race, color, national origin, familial status, religion, sex, and disability. We're going to go into each one of these a little bit so we understand them. Our first one is race. So there are 5 racial categories as defined by the federal government. And then again, it is a trickle-down effect. They are Asian American, African American, or Black, Native American or Alaska Native, Native Hawaiian or other Pacific Islander, and white. A racial category. Now, I am a Texan, tried and true. I do believe there should be a 6. I just feel it. Hispanic or Latino doesn't mean because Hispanic or Latino is not seen as a race that it is not protected. It does fall under a different protected category. I do get that question a lot. But if somebody's treated differently because of their racial category, that is obviously race discrimination. A big one that a lot of people know about that happened, I guess it was about 1.5 years ago now, was the difference in appraisals based on the race of the person who was selling the home. That was a really big uh, news story across the country, actually, that highlighted the difference in race. And again, that is differential treatment and it is discrimination. But that is a good example of race discrimination. The next one is color. Now, color is often confused with race, but it is different than race. Color is it refers to the pigmentation of your skin, whether you're lighter skin or darker skin. Just because I'm a history buff, there was a term leading up to and then right after the civil rights movement of the 1960s. It was a term called passing. And those who were lighter skinned inside a racial category were treated more favorably than those who were darker skinned of a racial category. So somebody was not treating an entire racial category differently, just those who were very predominant in it. And color was one of our 5 original protected categories that it's there to offer the full protections of the law. But this is where that discrimination, it is not on an entire racial category, just by somebody's skin color, usually those who are more predominant inside different racial categories. A lot of times, again, color is confused with race. We see a lot, if there's color, there's usually a race proponent, but not vice versa. If there's race, there's not always color. And then we have national origin, or as I like to term, ethnicity. As I was saying, you know what? I forgot the slide in there on this one because this is a new presentation. I apologize. I'm going to go back real quick. When we talk about race, as I said, Texas law has one area now when we talk about fair housing that has some additional protections, the Crown Act. And I apologize for this. The Crown Act was passed during this last legislative session over the summer and went into effect September the 1st of this year. The Crown Act prevents discrimination based on somebody's hairstyle or hair texture that is commonly or historically associated with racial categories. So it's it's additional protections on the race protected category, more so than federal law, which is just you can't be treated differently because of a racial category. The Crown Act extends that to hairstyles that are commonly or historically associated with racial categories. The law does state that it does include beads, locks, and twists. Now, I want people to understand that the law says beads, locks, and twists, but that is not an all-inclusive list. It is just some primary examples of different hairstyles and textures. It's not all-inclusive. It can include numerous other hairstyles or hair textures. That was the one area where Texas has added some additional protections on top of federal law. All right, so back to where I was at when we talk about national origin or your ethnicity. As I said, for those, when we talk about Hispanic or Latino, because again, we're a minority majority state, it would fall under this protected category because the federal government sees that as an ethnicity, not as a racial category. But the national origin, this one covers people based in your nationality, ancestry, your culture, language, beliefs, all of that stuff that makes us up who we are. Because whenever past point in the past that somebody moved to America, whether it was 1 generation ago or 20 generations ago, they didn't look like an American. We all look different and talk differently and sound differently. And that is all part of the national origin. I am American, but I might be from somewhere else or have some family history that we still honor and show about our ancestry. And so having that is, and if I am treated differently because of that, that would be national origin. If a property manager is refusing to rent out a South Korean, because I have some experience of this prior in the military, a South Korean property manager is refusing to rent to anybody who is Japanese in descendant, because there's a deep-seated animosity between those two countries. That would be national origin because they belong to the same racial category, Asian. So it's not racial discrimination. It is national origin discrimination because that's where that differential treatment is based in that ancestry, culture, language. Part of this also is limited English proficiency, English as a second language. All of those are encompassed within inside this national origin talk as well. And then this is one of our two protected categories, and not everybody's going to be a member of. So the familial status protected category covers those who have children. So now that child could be from anywhere between pregnancy to the 18th or 18 years of age. If you had a kid that moved off to college and decided to come back home and are back home living in their own room at 21, I'm sorry, if you can't claim them on your taxes, you cannot claim them for familial status. It is, if you to belong to this one, you have to be pregnant, have that legal custody of a child who is with them under the age of 18, either by natural being their parent or having that legal guardianship, or you're securing custody of a child. Now, when we talk about the familial status, I'm sure everybody's had a time to look at the signs below. Now, some people could be like, oh, I don't understand what's wrong, at least with the first two, because I'm just trying to protect my other residents. It's okay if you set areas for it, but just outlawing those activities that a kid can do with inside that community area is detrimental to those with families. It is that differential treatment to those with families. You can only, like no riding skateboards in between the buildings or on the sidewalk, because you are trying to protect residents who are walking around. No kids in the pool or spa. A lot of times lately, I've seen that one with more of a policy that says, any child, so anybody under the age of 18 had to have a parent or guardian. I always caveat that one. It is important. One thing to look at is if you're in a city and that city allows 16-year-olds to be a lifeguard at the city pool, then why are they not allowed at the age of 16 to be in the pool unaccompanied? So it is something important to look at when we talk about policies and procedures out there. And then, if unattended children are sold to the circus, I think it's probably more carnivals nowadays than circuses. Unfortunately, you can't do that if they're unattended, because you don't want to treat those families differently and try to make that's just illegal anyway. That one's more in there as my joke, but we can't set those different policies and procedures. I have seen cases where or issues where there is somebody who, a family of 5 is about to move into a home that I'm renting out. I'm going to charge an extra couple of $100s on a security deposit, because as a person who has kids, I know kids are destructive. And so I know that I'm going to have to probably repair a lot when that family moves. So I'd rather make sure I have my money first, then have my money maybe potentially on the backside. So I'm going to enhance my security deposit, but that decision is being based in somebody's familial status, not in an actual damages. So that would run afoul of the familial status protected category. And then religion. So the religious protected category covers those who belong to what we think of as traditional religions. You drive down the road and there is a Methodist church and a Baptist church and a Catholic church and a big non-denominational church. All those that have those hard-standing buildings are covered under the religious protected category. But religion doesn't only cover those that have that religious belief about right or wrong, but also that ethical or moral belief about right or wrong. And so those who are atheists, those who are agnostic, those who are Church of Scientology, pagans, they all fall under this protected category as well, because it's not just that religious, but an ethical or moral belief about right or wrong. And we can't base decisions in that treat one religion more important or higher than another one. Well, it's Christmas time. We only allow nativity scenes to be displayed as part of the homeowners association rules and policies. Anything that is outside of a traditional nativity scene is not allowed. But that is putting one religion, Christianity, above other religions. If I wanted to have a Jewish star or star and the moon, crescent moon, if I wanted to have those highlighted, I could face some kind of penalties because I'm not showing specific ones. So we can't set one religion above the others. We have to treat them all equally. And then our sex protected category. So our sex protected category covers your traditional notions of gender, being male or female, and that differential treatment. And it also covers sexual harassment. When we talk about the gender aspect of sexual harassment, again, it's going to be those notions of treating somebody differently because they are male or female. There was a young lady who just graduated high school and was moving to Houston to go to college. She was viewing an apartment and walked through the entire apartment with the apartment manager. And after the inspection, the apartment manager was like, "So, hey, I have a question for you. So do you have a boyfriend, husband, a male significant other in your life?" And the lady was like, "Nope, it's just me." She's like, "Well, unfortunately, I can't rent to you because this is a really bad area for a young lady to be living in, and it is not safe for a young lady to be living in it. So unfortunately, I'm gonna have to turn you away because you don't have a man." That is gender discrimination. There is that differential treatment. If it was 18-year-old me, and I'm telling you, 18-year-old me couldn't put his hand through a wet paper towel, that probably question would have never been asked because that was being based in that gender. Now, that conversation probably should have went along the lines of the same. Hey, this is not a good area for a young lady to live in. I would not recommend living here. If you were my daughter, I would definitely not allow you to live here. I think you should go look somewhere else. But again, that decision is ultimately up to you. It probably worked out for the best. And again, that decision was being based in the best of intentions. But remember what we talked about. Intentions do not matter. What matters is there was an impact. The best of intentions could still lead to that discriminatory act. And in that situation, that is exactly what happened. Then, when we talk about sexual harassment, we do have two different types. Hostile environment is the first one. And that is where a housing consumer is subjected to sufficiently severe, pervasive, unwelcome sexual conduct that interferes with their ability to obtain, maintain, use, and enjoy their housing or housing related services. Because remember, everything is covered under fair housing: brokerage, loans, lendings, all of that stuff, not just all of the typical things that we think about. So for it to be a hostile environment, sexual harassment complaint, it does have to be unwelcome. If two people are just being flirtatious with each other and they are okay with that, then there is nothing there that is being unwelcome. But if one person is not liking those sexual nature comments or innuendos, then we're not being welcome. So it is important to note that. And then it has to be severe or pervasive so as to interfere with that person's ability to use and enjoy their dwelling, their home. Now, severe is your very over the top, your very egregious acts. When we think of severe, it is typically going to be more physical touching, cornerings or blockings, those really big egregious acts, the unwanted genitalia pics in a text message, because it happens, those are going to be severe. And that's one and done. You're very egregious acts. Pervasive is minor incidences that occur over time. Now, the law doesn't attach a time frame and a number of incidences within that time frame. It just says pervasive. So that could be a couple of times a week, a couple of times a month, a couple of times every couple of months, is going to be pervasive. Now, pervasive is, again, it's the minor incidences, the sexual innuendos, the sexual nature comments. When I'm out stretching to go for my morning jog in my little shorty shorts, I'm being catcalled and hooped and hollered. That is going to be those little minor incidences. The first time that happens, not rising to that level of pervasiveness nor severe. So it's not legally sexual harassment yet, but by that second and third time, we're looking at that. The best way of understanding severe and pervasive when we talk about it, severe is like being bitten by a bee, wasp, or hornet. If you're working outdoors and you got stung by a bee, wasp, or hornet, you knew it. And if you haven't known it, you know you don't just go and reach and grab the wasp nest and just yank it off the roof, because you know it's going to hurt to get stung by one. That's severe, where you're like, wow, that really hurt. I got to stop what I'm doing and go concentrate on this, because that's kind of painful. Whereas pervasive is like mosquitoes. You could be working outside in the summer, and mosquitoes are just, they're around, they're landing on you, you're slapping them away. And, you can go for a while of just kind of slapping around a mosquito when you see them or you hear them buzzing around you. But if you've been outside long enough, and mosquitoes are just everywhere, you're like, I'm gonna go inside and get a drink of water now, because I'm gonna take a break. That's kind of the idea of pervasive. When it starts to become uncomfortable, it's not hurting necessarily, but it is becoming uncomfortable. And the other part of sexual harassment is quid pro quo. Now, quid pro quo is when someone is there is some type of submission to a sexual related request for some type of housing related service. And it could be, I'm going to evict you unless you send me some naked pictures of yourself. Or it's the middle of second summer here in Texas in September, and my AC's been out since first summer in July, and it still hasn't been repaired. And I can bump you up to the top of the list, Mr. Jeff, if you come over to my apartment for drinks and whatever else. There's that. It could be explicit as the first one, or it could be implicit as well, as in this, where there's that alluding to what is actually going to happen. And again, there is that housing related service for some type of sexual activity or sexual favor. And it doesn't matter if it is that threat or bargain that is being made, because one person sees it as a bargain, one person sees it as a threat. That is enough for it to be quid pro quo. And then on the other side, if I am sleeping with my apartment manager so I don't get evicted, that's still quid pro quo, and I can still file a housing complaint against them. And then it is just important to note, because I do get this question from time to time, that yes, in employment, gender identity and sexual orientation are covered, but the Civil Rights Act of 1964, which covers employment, is different from the Fair Housing Act of 1968. Those are two separate laws, and definitions don't just translate between laws, because that's how our system works. So because of that, what happened with employment in allowing gender identity and sexual orientation to be covered under the sex protected category doesn't automatically transition over into housing. So what happened was, at the beginning of the current presidency, Executive Order 13988 was signed that did add gender identity and sexual orientation by an executive order. But executive orders are just that. They're an executive order from the president. They are not law. And so if there is a complaint about somebody being discriminated against due to their gender identity or sexual orientation, that complaint would have to be submitted and investigated by HUD. We at the Civil Rights Division here cannot address that issue. And then our last protected category that not everybody is going to be a member of automatically is the disability protected category. So for this one, you do have to meet one of three requirements, and that is have a mental or physical impairment that substantially limits a major life activity, have a record of an impairment, or be regarded as having an impairment. When we think about that, now a major life activity is anything that you do, or anything that you do in life: hearing, breathing, seeing, walking, talking, learning, your body's ability to maintain its own internal bodily functions. And anything that substantially impacts that is a major life activity, is a disability. Now, not every disability is obviously able to be seen and observed and known about. So that's where that record of an impairment comes in, because you could have something that affects you that is there, but not always out there, always noticeable by other people. And then if as somebody is being treated as if they have an impairment by anybody within the housing scope, that they are part of this protected category as well. If you treat everybody the same until such time as you have to treat them differently, you will not usually run afoul of that last one, because we're going to treat everybody the same until such time as we have to treat them differently, because nobody has to disclose a disability until they want to. No housing provider or anybody within that kind of scope that is covered under the Fair Housing Act can ask that question. Now, some common impairments is your visual speech, hearing impairments, autism, muscular dystrophy, cancer, heart disease, diabetes, asthma. There is a lot. Anything that substantially impacts a major life activity. Now, this is not an all-inclusive list. This is just a smattering. It could be anything that substantially impacts that major life activity. Now, it's important to note that a lot of the complaints that we receive are a housing provider failing to accommodate for a person's disability. So we're going to talk about reasonable accommodations and modifications under the law. And then Joe and David will go into these a little bit more after. But it's important to note that the baseline is housing providers need to make reasonable accommodations to the rules, policies, practices, or services, or allow for the modifications when such may be necessary to afford a person with disability an equal opportunity to use and enjoy the dwelling. The reason why this is so important, and if you can see, may be necessary is italicized to highlight it. Probably should also put it in bold. Is that there has to be a correlation. The law calls it a nexus between a disability and a disability related need. Because a person has a disability, it's not like walking into Golden Corral and being able to eat anything that is on the serving line. No, the request, whether it's an accommodation or a modification, has to be tied to the disability. If it is not tied specifically to that disability, then we'll get into, can you deny a reasonable accommodation request? But it is really important to note that the disability and the disability related need have to correlate, have to have that nexus to them. When we talk specifically, what is an accommodation? So again, it is that change, exemption, or adjustment to policies, practices, or services. Now, this is usually changing the written word or exempting the written word. The ever popular assistance animals, which we will cover here in a little bit, are a reasonable accommodation, because usually they are not pets, and they exempt a lot of those policies that cover pets. It could be also, I have asthma, and by my doctor's recommendation, my air filters need to be changed out every 30 days with a specific air filter over every 60, 90 days. Or if you're my brother, you've never changed them out since you moved into your house. And so I have my doctor's note, and I'm like, hey, probably apartment, because I can't access the air filters. Most people, if you're in a home, you can. I'm like, hey, I need to have my air filters changed out on a 30-day basis based on my doctor's note because of my severe asthma. Well, one, we have that correlation, that nexus event, and now we are changing that policy, because there could be a policy where we change out air filters every, say, 90 days at that complex. Now we are changing the policy for me. It doesn't change it for everybody. If I'm asking for a parking spot to be assigned to me in a complex that is first come, first served, based on my disability, my spouse is now legally blind. And so there is no ADA parking near my building where I live. It's all maybe near the office. So I ask for that. That doesn't mean everybody gets now assigned parking spot because I do. That is just exempting that one specific for myself due to that disability. When we talk about modifications, modifications are going to be the physical change to a structure or a dwelling. Now, it is important to note when we talk about modifications, they are typically going to be at the owner's own expense. Anything involved in the expense of that modification will be paid out by the tenant. Now, there are some exemptions to that. The biggest thing is just if there is money coming from other sources, say being a TDHCA low income housing tax credit, Section 504 property, where there are tax credits or subsidizing the management of the building, then the owner might be on the hook for the modifications. But in typical situations, it is going to be at the tenant's own expense. A lot of times, these are going to run of ramps to go in and over stairs. Grab bars in the bathroom are actually a really big one. So having those grab bars added to bathroom walls. I have heard for those walk-in tubs as well. But a modification, you're looking for that physical change to a structure or a dwelling. When we talk about some rules for reasonable accommodation requests, it's important to accept verbal requests. And I say that in so that most people nowadays are going to have some type of system in place that is digital in order to track requests, whether that's a portal, an app, something. But we can't turn somebody away because they haven't gone to that system yet. We have to accept verbal requests. I hear you need that parking spot, Mr. Riddle. We're going to get started on that right now, but so we have a record of everything and we can track this and everybody knows what's going on. Can you go on the portal and right below maintenance request, you'll see the accommodation request, and can you fill that out for us? If not, I can help you out with that. But we can't be like, well, you didn't go online first. Unfortunately, I can't do anything with that until you go and fill out a request online, because you do have to accept those verbal requests. Begin that interactive process immediately. That is very important because somebody might want something very big and exaggerate that they saw on TikTok or Instagram that you just can't afford to do. So we're going to try to still find something that will meet the ends of what you needed to do, just not that really expensive thing that you're talking about. Have that, carefully draft, review, and revise policy on a regular basis. That way everybody is treating everybody the same until such time as you have to treat them differently. Make sure to get that appropriate, reliable disability related information. The doctor's note. I say doctor's note, but it is important to note on that. It's not just has to have a doctor's scribbling at the end. It has to be somebody within that medical professional field. Doctors, yes, are great, but it could be a nurse case manager who has no background in medical whatsoever, but they are in that position to know about that disability and that person's disability related needs. So it still has to be somebody within that professional sphere. Provide prompt responses and document all actions, interactions. It is important. Sometimes you may not be that person that is the deciding factor. As somebody who grew up in military communities, I could be renting a home and the person I'm renting it from is on the other side of the world and not always behind a computer. And that's okay. But a delayed response on that person could be deemed as a failure to accommodate. So it is important, if you are that middle person, to stay on top of it. Or, hey, you might be out of the loop for a while. Do we have permission to do up to this level, approve request up to maybe this type, or anything below that? But it is important to provide those prompt responses, because without it, it could be seen as a failure to accommodate. But can you deny a reasonable accommodation request? You can. I don't know who would deny that cute little chocolate lab puppy there, but it has happened. But you can if that person poses a direct threat, and this does include service animals. But it's important to note that whether it's a person or it's a service animal, it has to be a direct threat. It can't be an implied threat. An implied threat is just that. It is an implication, but it isn't actually that is something that is happening. So it does have to be a direct threat. There has to be things going on. It can't, that Rottweiler, it's a dangerous breed. We can't allow it because it's a dangerous breed. Remember, things, reasonable accommodation requests exempt those kind of things. But it is important to note, too, that it has to be a direct threat. There was a lady that had a lemur, I believe it was, as a reasonable accommodation, but that lemur started becoming threatening and hostile to other tenants within the complex. And after multiple complaints, there was a direct threat going on, so they revoked that lady's reasonable accommodation request for that animal. And even though she tried to fight it, it was ultimately deemed that there was a direct threat, and so they were able to deny and revoke that accommodation request. Again, if there is no disability related need for the accommodation, so remember, there has to be that correlation, that nexus between a disability and a disability related need. And then ultimately, if that request is going to be a financial and administrative burden. So if I'm a manager of a 2-story apartment building complex, and somebody's asking for a residential elevator to be installed because they can't easily navigate the stairs to get to their second floor apartment, I'm more than likely not able to afford that. So I will need to try to still find. Now that's the thing, is I can't get you that elevator. So sorry, you're going to have to figure it out because I can't give you what you want. I still have that responsibility of finding something that is financial and administratively able for me to accomplish, which it could be me moving them down to a first floor unit. But there are also other aspects, but I don't end when I can't give them what they want. I still have to try to accommodate for that tenant. So there are some exemptions to the Fair Housing Act. The first is 3 or less properties. So if somebody has 3 or less properties that they own, they're leasing, they're selling, they are exempt to the Fair Housing Act. But at any point in time, with this one and our next one, if you engage a service, so a property management company, a realtor, and Zillow, realtor, Redfin, whatever, those places don't get to assume your exemption. So I don't want to rent my home to people with families, and I tell my property manager that I only have one property, but that property manager is covered under the fair housing law and they don't have an exemption, so they cannot do that. Now, if you put a little for sale sign out front and somebody with the family comes by and you're like, I'm not going to rent to them. Okay. But the minute that you, again, remember we talked about publication. If you start making discriminatory statements or ads, put our for sale, no families need apply. Now we're getting into that publication aspect, and we could run into some problems. But there is that 3 or less properties exemption. Same with the Miss Murphy exemption. It's that time of year. So if anybody remembers the great classic Christmas movie, It's a Wonderful Life, Jimmy Stewart's mom was running a boarding house. Now, I know boarding houses are not a thing anymore, but the idea of a boarding house. I am living in a home and I am renting out rooms in the home. I can rent out those rooms to whomever it is I see fit, as I deem fit. And I can do that. But again, the minute that you engage in a service, they do not get to assume your exemption. And then we have housing for the elderly. So when we talk about housing for the elderly, the properties need to either be designed and operated to assist elderly individuals, they are intended for and solely occupied by people who are 62 years of age or older, or 80% of the occupied units have at least one person who's 55 years of age. And those are protected from me and my household moving into the home next door to my Nana because I want to live next to her. They are designed specifically for the elderly. So you would have to meet the requirement that they are falling under. And that's either the big complexes or even the neighborhoods. And then religious organizations and private clubs they're the different sides of the same coin. They have the exact same idea behind them, in that if a religious organization or a private club owns a property and allows their members to utilize that property, they can do that at the exemption of anybody that doesn't belong to their organization or club. Now, with that being said, is if either the organization or the club makes that property public, so they're trying to sell it or they're trying to rent it out to the public, then they fall back in on the law and they cannot exclude somebody because they don't belong to that religious organization or private club. But if it is internal, it is owned by that club organization and only for the use of that club organization, that is okay. But the minute it becomes private, that it does run afoul. All right. So when we talk about responsibility for or for anybody within the fair housing, it is important to follow and uphold fair housing laws. It is important to train employees in fair housing laws to make sure that they are up to snuff. Treat everybody in the same manner. Even if you know you babysitted that person, you know what they're dealing with, you still treat them the same. You still make them get all the same documentation as everybody else. That way you don't have that differential treatment, and you can open yourself up to perceptions or complaints. And you do that by having standard procedures that allow for everybody to be following the exact same thing. So we're not running afoul of the law and treating people differently because of whatever reason. And if you ever need to file a fair housing complaint with the Texas Workforce Commission, you just go on to twc.texas.gov, go to programs and then all programs. You'll find the civil rights page. On the civil rights page, you will see linked, to both our employment side and our housing side. Click on our housing side. You will find some great information. A lot of stuff we covered here, basic rights. You will also see how to file a complaint. Just click on that link, fill out the form, and it'll be routed over to one of our intake specialists who will reach out to you usually within 5 business days. If we could be having a busy week or month that month. It might be a little bit longer, but we're really good about getting back with you. And I'm going to turn it over to Mr. Joe Rozier. Thank you, everybody.
Thanks, Jeff. So I know a lot of you thinking, hey, that's great. You know, I sell homes, I show homes for a living. What does this got to do with me? Well, fresh off the press, folks, we have this complaint in our office that we're currently investigating. A qualified Black applicant through their real estate agents that they hired found them a condominium in downtown Houston area, listed by another real estate agent who's representing the owner. Our complainer, the applicant, submitted a colored copy of their driver's license with the application to the listing agent, who forwarded it to the owner. The same day, in fact, within mere hours, the owner, through their agent, rejected the applicant without a reason provided. The owner's agent had no explanation for the rejection, and no further action was taken. The applicant has since filed a complaint with TWC. What do y'all think? You think that's valid? So without getting into all the details of this, because this is an open and active case, I can tell you that the evidence at this point shows that, first of all, the respondent in this case are going to be the owner of this condominium who made the decision and their real estate agent. And since she works for a broker, the broker was also named as a respondent. It means they're going to be on the hook should the state of Texas, the Attorney General, decides to take them to court for a fair housing violation. Now, the real estate agent herself has been cooperative with us. She took no further action to advise her client that, hey, this appears to be a discriminatory action. The evidence does appear to show that the owner of this particular condo did not want Blacks living in the apartment. We did a history check on him. We checked about the last 3 years of records for other units. He owns several units in the Houston area, several condominiums. He owns a couple of single family homes in the Houston area, none of which have ever been rented to Black families of any kind. In fact, this particular unit, within a month of rejecting these applicants, he rented the unit to a much less qualified white male who required his parents to be the co-signers on the lease. And again, the real estate agent who represented him is on the hook for this as well. Now, she's been cooperative with us to this point. The general wisdom by us and our general counsel is that the owner of this property made the decision on their own to discriminate. But we believe the real estate agent had an obligation to instruct their client, in this case, the owner of this property, do what you can to find out what was provided. And if it's truly a discriminatory action, which it appears it was, you should probably have a say in that. So that's kind of where you guys stand. What you don't want is for me or one of my other investigators to be calling you on the phone As Pat Williams told you guys earlier, we have a partnership with state agencies. One of those state agencies is the Texas Real Estate Commission. We work closely with them, which means they're privy to some of the times you guys are respondents. And if we go cause in a case against an agent, they're likely to know that. I don't know whether that affects people's licenses or not, but that's something to be cognizant of when you are showing properties. But that is one example of how it affects you guys directly, particularly if you're in the property management business as well. This was an agent who simply showed the unit. She wasn't the manager of this property, but she did show it and was named as a respondent. What do you guys think? Anybody from the audience have any questions about this? Are we taking questions yet?
We are. Yeah, we've been taking questions throughout. So if anybody has any questions, you can go ahead and put them in the question bar. If not, we will get to them at the end.
So I see one of the questions is, what if the listing agent did advise the owner of the Fair Housing Act and the owner did not take the advice? Well, that's certainly a defense. We would have didn't tell them. She just kind of went with what his answer was. And she is a new real estate agent who's still kind of getting her sea legs under her. But again, it's no excuse. But it would go a long way when you explain to somebody. But in this case here, she turns around and she's representing him in another apartment matter. Now I'm thinking I'd have a come to Jesus moment with the owners of this property and say, hey, we're already under investigation for this. You might want to have and part of the issue is, as Jeff talked about early on, communication is key to these. You guys need to have policies. You're going to manage properties. There should be written policies in place that show you're treating everybody the same. That means rental criteria. It's the same for everybody. In this case here, he didn't have any rental criteria. He just kind of ran this willy-nilly, told the real estate agent what he was looking for. In this case here, he was looking for a much younger white guy to rent the property to because he didn't want blacks living in his property. What should the agent have done in this case? Well, I think you go back to the question we just asked. I think they could have done a better job of educating their client, and that's part of this. We're here. You guys here to learn. We're here to teach. Educate your client. Part of that, if you're going to be a manager, or if you're just going to show properties, I think the first meeting you have with your client is, hey, we abide by the Fair Housing Act. Fair Housing Act says you got to treat everybody the same. You have to rent or sell to the person who meets the qualifications despite their protected class. Question is, if we receive multiple applications with everyone meeting criteria, but landlord prefers to rent to military tenant because of landlord's military background, is this discrimination? I'd say absolutely not. If you got 3 people who are equal, at this point, veteran status is not a protected class. It should be. I think that's coming. I think there's been some scuttlebutt about that, actually. I think if all things taken equally, as long as you're using some criteria as a tiebreaker that doesn't violate the Fair Housing Act, I think that's perfectly acceptable. If the listing agent terminated the relationship with the owner, would that make a difference? Absolutely, it would. At such a time, she decided hey, this appears you've violated the Fair Housing Act. I've told you you can't do this. I can no longer work with you. That would have gone a long way. Again, that didn't happen in this case. She has since been cooperative with us. I hope that answers everyone's. I mean, I know you guys have a lot of questions, and manager Pat Williams said earlier, our phones we're always available to you guys. We're always available. Pick up the phone. We're not. I have a saying that I've been working with side by side with HUD for a number of years, and HUD is a hammer and everybody's a nail. And some people believe that, so they're afraid to reach out to us. We are not that way. We would prefer to educate people rather than take action against you. So if you have any questions, feel free to reach out to us.
Thanks,
Dave,
Joe.
go ahead and go to your case study.
Real quick, y'all. If you have any further questions on the example that Joe gave us, you can feel free to go ahead and throw them in the chat. If we cannot answer them at the end of the presentation, we will definitely reach out to you with another answer. And then, like he said, we are going to provide some information for y'all at the end with how to reach these gentlemen. So stay tuned for that. That way we can get as much education as possible for everybody.
David, you up?
Yes. Good afternoon. Essentially, my case example here is essentially the same thing. However, it seems like you guys are already asking the questions that I would be discussing. In this situation, this is a homeowner that had two applicants. One of them had a disability animal, a service animal as well, and their policy was that they had no pets. No pets were allowed. However, when the applicants applied with their service animals and the documentation that was required to approve their animals, the realtor, or I'm sorry, I apologize, the owner actually chose that they did not want to rent to that owner or that applicant because of the animals. This would be addressing that question that you had just a second ago. The realtors actually did provide the owner with all of the information, with all of the guidance, and explaining to them that they are not allowed to not approve of residents simply because they have an animal that's for a disability need. And so in this situation, the realtors are not being held responsible for the actions of the owner, because the realtors actually took the steps that were necessary to inform the owner and to provide as much education and to let them know that that is not something that they're allowed to do. And if the owner made that decision for themselves, and they are the ones that make that final decision to approve or deny, with the with the realtors providing that information, they essentially have covered themselves with regards to how this discrimination investigation would have taken place. In this situation, in example number 2, the realtors are not being held responsible for the discrimination from the owner. In contrast to the example number 1, in Joe's example, the realtors were being held responsible because they did not provide the homeowner with that necessary information. And so to answer that question that you were asking before, if the realtor does provide the information necessary, they are not going to be held responsible for that. Reading one of the questions from Christy Armstrong: is the leasing agent obligated to determine why the owner did not rent to a certain applicant and provide that information to the applicant? The agent is not necessarily required to provide that information. It's probably more so of if the owner provides the answer to the realtor can just essentially just relay that answer. They're not required to provide that answer to the applicant. However, if the applicant then does ask the owner directly or request that information, that is something that is probably something that's more done as a courtesy if the realtor wants to provide that answer. The question from Cindy Bell: if an owner broker is found in violation, is there a fine? We don't necessarily determine fines. Our investigations would only provide a recommendation based on the evidence and information we obtain. So if our evidence and information does indicate that there is a cause for discrimination, which would mean that we have enough evidence that makes us believe that discrimination occurred, that from that point on, that information goes to our legal department and to the Attorney General's office. They make that decision on whether or not they are going to move forward with court. And then in court is where there will be any kind of fines or anything or penalties levied at that point. We don't make any kind of final judgments. That's all something that's done by a court in a court system. So that would not be up to TWC.
One thing I would like to add on that particular point about the fines, the relationship we have with the Texas Appraisal, Licensing, and Certification Board. When we have the memorandum of understanding we have with them, they will refer complaints to us. We will triage those complaints, determine if they're jurisdictional. If they are, we will investigate them. And based on the outcome of those complaints, if a complaint is determined to be a cause, the appraisal board will take the determination that we will publish and provide to them and use it to make a determination how they will deal with the individual appraiser. That's in all cases. So we provide them a report once a month on the outcome of any cases or complaints that closes that they refer to us. Since that MOU was approved about 15 months ago, we've had somewhere in the neighborhood of 20 complaints referred to us. A dozen or so have closed. A couple have settled. And again, the appraisal board would take the outcome of those. We provide a copy of the settlement agreement, the terms, but they will make a determination on how they will deal with the licensing and fees and how they will deal with that. That's all done by the appraisal board. We don't get into dealing with the individual appraiser. We don't have that type of current relationship with the real estate association. How that would develop, don't know, but we don't have that relationship. If there is a complaint, where that would go. I mean, don't have that. That's something Gabrielle was going to talk about you a little bit later. That's something that you guys are interested in. But that was just a comment I wanted to add on that particular point.
And David, if I may add real quick on the question about the fines, if you find yourself on the business end of one of these investigations, meaning that you are named as a respondent, we do engage in what y'all refer to as mediation. We call it conciliation. We like to resolve these issues long before there's a court assessing a fine against you, or before it gets that far. We try to resolve it through a very informal, and it could be some financial incentive paid to the parties. But before it ever gets to fines and court decisions like that, we resolve probably, I don't think the last time we've gone to court on one, probably 95, 96% of our cases are resolved through the conciliation process.
That'd be true. The last one, and again, the ones that did make it to a charge, all of those eventually were settled in court. I mean, out of court. I'm sorry. The parties came together and settled because they did not, even though the charge was filed, they just wanted to settle that complaint. And again, that is an option that we prefer. I mean, we really don't have a dog in the fight once a charge is filed. I mean, it's out of our hands. That's up to the attorneys. But again, it seems like that is the preferred outcome for once we have a charge filed and move towards a potential trial. David, back to you.
Next slide, Jeff. This slide here is regarding breed and weight restrictions for service animals and or emotional support animals. There was a question in the chat just a little while ago with regards to this question, or with regards to this topic. For service animals and emotional support animals, they do not fall under the breed and weight restrictions. If they are a service animal or an emotional service animal, they're not considered pets, and therefore 9 times out of 10, the breed and weight restrictions are a pet policy. And so once those animals are considered service or emotional support animals, they are not considered pets. And so they cannot be denied simply because of breed and weight. However, based on the slides that Jeff had provided previously, if there is any kind of danger, or if you feel like there is imminent danger from that specific animal, you may be able to deny an animal for those specific behaviors. Not on an implied behavior, but like I said, as for a specific behavior that's been demonstrated by that animal. Next slide, Jeff. The verification request. This is, again, part of what Jeff had talked about earlier in the process. With our accommodations, or with their accommodations, there needs to be a few different requirements that are met. We have to make sure that the person that is requesting the accommodation is a person with a disability. We have to make sure that the respondents or the property owners are aware of that person having a disability. They need to actually make a request. They need to make sure that that request identifies a nexus or a connection. And then we also have to know what the disability is with regards to if it's a physical or mental disability. The disability needs to explain if there is a limitation in a major life activity, and how that accommodation that they're requesting would help alleviate that limitation in their life activity. So those are all parts of what is required or a part of the verification request part of the accommodation and policies. Next slide. There have been, we see this a lot now due to COVID. There are lots of online services that do provide telehealth or assessments for I guess disabled people over online services. That is an acceptable way to get some prescription letter if the person has knowledge of your medical history. We don't allow, or it's not allowed for a person to just simply find a person online, pay a fee, and then pay that fee in order to get a prescription letter. The person that does not establish a medical history or medical relationship with the complainant and with the medical practitioner. So that is part of something that is necessary. Although we are aware that you can have a telehealth meeting with someone for maybe an hour or 2 hours, and that could be considered enough information to be able to provide an ESA prescription or a service animal prescription for that person. However, again, if it is simply just the only time they met and spoke was simply to pay a fee and obtain that letter, that would not fall under those requirements, and that would probably more than likely not be deemed a credible letter or a sufficient letter to meet that accommodation requirement.
Hey, David, real quick, can I address, somebody just asked about the insurance, and I think I need to go into a little more detail about this. Someone asking you, insurance companies will claim, and this happens, where they will not insure a property because of breed restrictions. The agency has more than one time named a insurance company as a respondent. The answer to that is find another insurance company who will. Because the fact is, that is not a valid defense to say that my insurance company will not cover a certain breed. That's not an acceptable defense.
And that question was also posed earlier. Again, we do have some guidance with regards to insurance for service animals or emotional support animals, so we can provide that information at the end of the conference or training as well. There is also a question of how do we verify that the physician has a medical history with that potential tenant. That's one of those questions that you can ideally the person will actually write that information in their support letter. They may say that, for example, they may say something to the effect of this patient has been under my care since 2021, or this patient has been under my care for the past 6 years, or something of that nature. That would also establish that. However, if that's not written in the letter, the best you can do is probably get some kind of, I would suggest that you get some kind of HIPAA authorization to be able to speak with that medical practitioner or medical person. Or if you have documentation that you want to provide to the tenant and put that responsibility back on the tenant, you are welcome to do that. You can provide the tenant with the information that you need to know. If the medical history is one of the questions that you have, you're welcome to say that we don't feel like there is an established medical relationship between yourself and the medical person. If you can provide us additional information to support that will be helpful. And again, you can put that responsibility back on that tenant, the tenant that's requesting that accommodation. It's not necessarily something that only the respondents have to be working on. Part of the process is an interactive process where you go back and forth. How we try and explain it is similar to a tennis match. When the complainant or the tenant requests that accommodation, they're hitting the ball over to the property owners. If the property owner requires additional information, they let the tenant know that information, know that they need some additional information to be able to make a decision, and then that essentially is hitting the ball back over to the complainant or to the tenant. And so that way it doesn't have to be just you guys working on it or just the respondents or property owners working on this process. This is a process for both the complainant and for the property owners. And again, it's when they're requesting an accommodation, they're requesting an accommodation because they need it for a disability. So there is no requirement for you to give them exactly what it is that they want. You just need to make sure that you're trying to provide them what they need to meet that limitation, that major life activity that's limited. So it doesn't necessarily have to be exactly what they want. If you have an alternative that could also meet the need of what they're requesting for, you are welcome to offer that as well. And again, it goes back and forth like the tennis match. You offer your alternative, the tenant or the complainant would then need to provide you a response of either yes, that alternative will work, or no, that alternative would not work, and explain to you why that alternative wouldn't work. And then they can also provide you a different alternative. And that's hitting the ball back over into your hands again. So it goes back and forth. It's not something that you only have to do where you have to give them exactly what it is that they asked for.
But again, the most important thing is communication. And the fact that, you know, you're going back and forth, you're actually communicating with the complainant. And that's what's important, especially for those involved in property management. Same thing for you realtors. You may not be involved in property, but it's so important when you're talking about reasonable accommodations that you're communicating with the complainant. And then Jeff mentioned it in the chart up front. You document. Everything's documented. Every conversation, although it was a verbal request, well, you go back and you write a note, you know, and follow up with that complainant about exactly, hey, what took place. You know, in some cases, you may not be the decision maker. You have to send it to corporate. Well, if you have to send it to corporate, well, that's great. And a lot of our classes with the apartment association, those in corporate now attend those because they understand the importance of it. So they're attending those and understand that they have a need and a requirement to respond in a timely manner. That it's not taking forever for them to respond because one, it puts the leasing agent in a bad predicament. But as long as you're communicating, that's the key thing. I mean, really, that is the key thing. And again, I don't think we would receive a lot of our complaints if folks were just communicating. And a lot of times that's what happened. Somebody breaks down. And if it's the respondent, it's not good. You're going to get a fair housing. You know, I mean, that's just the reality of it. It's going to happen. So, I mean, communications is a priority and documentation. You do those things. And then I mentioned it up front, you know, education is great. I mean, enforcement is one way to deal with it. But education, I think, is the real way out because if people are doing the right thing and people are filing complaints, but, you know, and you know what you're talking about, and you know that you can get on the horn, talk to the Civil Rights Division, talk to others in this business, and know that they're not the enemy. I mean, that we're all kind of in this thing together. I think everybody cares about fair housing. So I would just say, hey, communicate and document what actions you're taking.
There's a question regarding if the realtor, the buyer's agent, and or the property owner's agent is required to verify the prescription letters. That is a no. They're not required to unless they are the decision maker. I would suggest if the buyer's agent is aware of the process or aware of the accommodation requirements, if they see the prescription letter, I would suggest it's probably a good idea to inform your buyer if the information that's provided in the letter is sufficient or not. But that's not something that you're required to do. Only the decision maker is the only person that's required to verify whether or not that the letter is sufficient or not. Next slide, Jeff. Hey, this is the insurance question. This is the one we've already addressed this one earlier. You guys are a little bit faster than our slides are going. So there are requirements with regards to insurance. Like I said, we'll provide you guys guidance of that information. For the most part, if an insurance agent or an insurance company is not willing to provide insurance for a property owner, that could also be considered a violation. So it's possible that that could be an issue, but we will provide you that guidance at the end of this training as well for that. And I think the next slide was simply, the interactive process. This falls in line with regards to the communication. In our experience, a lot of the times when there's an accommodation request or a modification request, a lot of the times the requester files these complaints with us when they haven't had enough communication with the property owners or the property providers. That's usually the issue. It's usually that they've requested it, they haven't received a response, and so they don't know what's going on. And that's usually where the problem is. So we always suggest that you participate in the interactive process. That could be even if it's just to say that we received your accommodation request and we're looking into the situation, and we'll be able to provide you a response at a later time. That's part of the interactive process, to let them know so that they're up to date as to what's going on with that request. Like I said, it's 9 times out of 10, it's usually the communication, where the communication falls is when there becomes an issue. Next slide, Jeff. With regards to this slide, there are times where an accommodation can be denied based on what it's saying here as well. If the person brings this is more so for or apartment complexes in our experience. If a person brings an animal onto the property without the property owners actually knowing about the animal and on the property and ahead of time, it's possible at that time that then it could be looked at as the animal is an animal or it is a pet, is a pet and not an ESA or a service animal. It doesn't necessarily mean that it can't possibly be. Once the property owner is aware of the animal being on property, if they have some kind of violation process or they request some kind of security deposit or monthly pet fees or something of that nature, they can request that from the tenant at that time. Because at that time, they're not considered an ESA or a service animal. At that time, they are still considered pets until they actually provide the information or documentation or to support the need for the ESA or for the service animal. The animal would still be considered a pet. And so you are able to follow through with the pet policy that may be on the property at that time. Once they do provide an accommodation request or a support letter, then you may have to look at the animal as different based on that information and the support that's provided. Next slide, Jeff. I think that might be the last one.
All right, y'all, I'm gonna step in here and we'll have all the guys turn on their mics. I'm gonna go ahead and read out some of the questions really quick. I know we're kind of short on time. I'm more than happy to stick around, or if you guys want to email these questions as well, you have some Pat's email up there. I'm sure he's more than happy to answer questions. And then my email as well is the one that came from the Zoom invitation. So I've been taking some of these questions that you guys haven't read out loud. So let's start with, I'm gonna actually go do this one if you guys don't mind. What are thoughts on using a third-party screening company like pet screening to limit liability to a property manager, real estate agent, or owner? So from Texas Realtor standpoint, beautiful. We love to see it. It's a lot easier for them to go ahead and do that. That way you're kind of just not having to be that middleman. What are y'all's thoughts on that?
Well, pet screening is something that we've been seeing a lot of lately. There are a lot of property owners that do use petscreening.com to I guess review those pet applications or any kind of pet brought to the property. I would say it is good to use because I guess it does alleviate you guys having to be the decision maker or the final say on that kind of answer. However, it also, in my opinion, in some of these cases, it also can be a delay, an unreasonable delay sometimes, because in situations that we've seen recently, if you have an animal even if it's an emotional support animal or a service animal, or if it's just a pet, they all have to go through the screening process. Sometimes when it's an emotional support animal or service animal, that screening process takes a little bit longer than it does for a regular pet to be screened, because again, there may be some support letters that maybe have to be provided and have to be verified and confirmed. So sometimes it does look like it does appear as a delay. Sometimes there are, in recent cases, we've seen where a disabled applicant may submit their information to pet screening. It may take them about 7 to 14 days to be able to actually confirm or verify that letter. And during that same time, other applicants, maybe non-disabled applicants, may apply with a pet. And that takes maybe 2 or 3 days to be able to verify. And so in that sense, the person with the pet, even though they may have applied after the person that was disabled submitted their information, the person that only has a regular pet may get their answer a lot sooner than the disabled applicant that may have applied with a service animal or emotional support animal. So I in my opinion, that's a kind of a tricky one to use, but it is helpful. And it's not, there is no violation with using pet screening to be able to address those kind of queries.
There we have it, y'all. It's kind of a double-edged sword, but it can help, and it can, you just have to make that determination on your own. So let's see, we've got, this one's kind of lengthy. Is there a distinction between a service animal and an emotional support animal? My favorite question.
Well, emotional support animals are basically for someone that has an emotional need for it. It's not necessarily, it may not necessarily provide a specific service. For example, a CNI dog, or a dog that may be able to help you identify if when you're getting ready to have a seizure or something of that nature, may be able to warn the person that a seizure is coming. That would be considered a service animal because they are providing a specific service that is helpful for that disabled person. The emotional support animal, essentially any animal can be considered an emotional support animal if you have a disability that requires it. So the service animals are more so trained to provide a specific service based on that disability.
And the important thing to note there is that they are not pets if they are either emotional support animal or a service animal. They're all in that
Correct.
umbrella of assistance animal. So let's see. How about animal species? That's a good one. Do you want to answer that, David? Or I think somebody actually answered it in writing, and we can just go with that answer.
Animal species?
Yeah, so as far as like, is there an animal species requirement? So I think, yeah, Joe answered it. Reasonableness is the standard for an ESA. So for a service animal, it has to be a dog. Very rarely miniature horses are approved, but that's not not much of a thing anymore. For ESAs though, Joe said reasonableness is the standard. It can be almost anything, but they're likely, a doctor's not going to approve a crocodile as an ESA, or something crazy, something dangerous, those type of things.
Yeah, and one of the other questions that I think you may have sent us in advance was the number. How many emotional support animals can somebody have? And then again, we've had some cases where an individual had, let's say it was a dog, but then they had a cat as well. As long as the medical provider can provide documentation where that the dog provides a certain service, it's providing a particular service, and then the cat's doing something else. Now, so we've seen that. Where you can run into some real questions is, well, they have 6 hens or 6 chickens. That can be questionable because you get into these numbers. And what is the 4th chicken or hen doing at the 5th one that's different? Because you have to get in front of it. And I mean, I get in front of it. If you've approved 2 and now somebody's coming for a third and it's still a chicken. Well, you need to know and understand what is the third chicken doing that the first and second one isn't. You know what I mean? And if they can't provide that kind of detail, that nexus, then you probably don't want to approve that third. No, they need to be able to show that. Otherwise, you can end up with 6, 7. We've had it. Somebody's had 6 chickens. You know what I mean? But you just have to be able to make sure you get in front of it. And one of that's by having a policy. And if you have a policy and how you're going to go about processing these procedures, it becomes a little easier because you're following the same protocol and process every time. You won't slip up, and fall behind the power curve. And now you have an alligator, being a little facetious.
Right. And so that is also where Texas Realtors comes in. As y'all know, we have our forms. And so one of the leasing and property management forms, we have the general information for a landlord regarding assistance animals. We have plenty of informational forms. And then we also have model forms that you can find on our website. And one of them is a model form of tenant selection criteria. So in that situation, you would provide that to people when they apply so they know going in that every single person gets that same tenant selection criteria. Everyone going in knows what the standards are. Which can be incredibly helpful with not having to make those off the cuff decisions. So let's see, we've got, on that note, we had a question at the beginning saying, can you say that you won't lease to someone with a DUI on their criminal record?
Yeah, I provided a response to that one. It's criminal records. That's a tough one. What we suggest is that you consider the offense and the time of when the offense occurred. And another thing that you also need to consider is was the person actually convicted or were they simply arrested for the offense? It can be considered an overly restrictive policy if you deny everyone that has a criminal history just simply anything that if they were just arrested, and you deny everyone simply because they have an arrest, that could be deemed as an overly restrictive policy. And the same thing for if there was some kind of offense that may have taken place maybe years ago, we would suggest that you have some kind of reasonable time frame on that policy to try and address each one on its own face.
All right. Let's see. Does familial status extend to someone with no children as well? I believe you gave a written answer for that, but do you want to address that to everyone?
Well, familial status is only for people that are expecting a child and or has children in the household. It would not go for just anyone that does not have children.
Okay. This is a good one that I really want y'all to address. If we have a fair housing complaint, is there a time frame that you have to have responded? And is there a time frame that someone has to file a complaint?
With regards to filing a complaint can be filed within 365 days from the last date of harm, meaning the last time that they experienced that discriminatory action. They have all the way up until 365 days to file that complaint. With regards to a time frame to respond, once there is an investigation that we start, we do send out notification letters explaining our investigative process and explaining the deadlines and the timelines that we have with regards to providing evidence and information. 9 times out of 10, you're probably going to need to provide some kind of response within the first 14 to 21 days of receiving that notification letter. And then as the investigation continues, there may be additional requests for information or different additional attempts at trying to interview property owners or respondents at that time. And as long as you're cooperating and participating in the investigation, everything should be fine. It becomes a more difficult situation when we can no longer, when the parties stop participating in the investigation. So there is no set timeline as to what time you have to respond.
Perfect. All right. Another Good one. Do you guys share any violations that you find with Trek?
No.
No, not
No.
at this time. One, and part of that's because, can we do that? Most likely. That could probably happen, and we'll chat, Gabrielle. We'll chat, and we could probably establish some type of protocol how we can do that, because it would be good information for you all to have and know and understand. And again, I can share with you what we currently do with the appraisal board and how that relationship work. So yeah, so that would be fine.
Okay.
We could probably work something out there.
Okay, great. And then let's see, what about, we've got time for probably two more, I think. So let's do, they're both going to be animal ones. What about an application or an applicant that applies with documentation for an assistance animal, and then it's later determined that they're breeding and housing before selling the offspring?
Well, that's not an accommodation or a modification of any sort. So if they're breeding or selling their animals or something of that nature, that's a completely different kind of issue than accommodation or modification. So I would say that would fall under whatever your policy or procedure is with regards to animals or people breeding animals in their units.
And I think
There's
our department, the legal department, has gotten this question before, and I believe what we determined was that, that offspring is no longer just the ESA. So if they have that,
right.
Reasonable accommodation for their ESA, that doesn't extend to the offspring. So, they're technically out of bounds. Those little cute baby sweet puppies are now pets, unfortunately.
They are
So,
considered pets.
they're so cute, but they can't have them. So that would be something that would probably need to be addressed. You could potentially, yes, probably charge a pet fee for that, et cetera, et cetera. So let's see. We have lots of questions about pit bulls. So let's attack these ones real quick. So one is kind of a subjective situation. Two applicants applying for a property. Each of them have two ESAs. All four of these ESAs were pit bulls. What are thoughts on this being a legitimate situation?
For us, as long as if they provide documentation and information to support the need for those animals, then they would be considered ESAs, and that would be for each animal. So if both applicants are bringing two pit bulls onto the property, then ideally they should be able to provide you support indicating that both of those animals are needed for a disability purpose. If they can't, then you can deny those animals if you don't want them on your property. But if they are ESA animals, if they have the supporting documentation, the only way you can deny them because of their breed would be if there is a specific danger posed by that specific animal.
Okay, perfect. And then let's see. Okay, so Tammy, I see that you noted that all four of them were pit bulls. The only thing I can think and really speak on that, as far as it being a legitimate situation, I know that here in Austin, we have a huge number of animals that are being adopted out right now, and a lot of them are some kind of, pity cousin or sibling. So, a lot of times they may look similar to a pit bull, but also take that into consideration. I'm can't speak to the legitimacy of that specific situation, but do take that into consideration that, we are seeing a lot more, especially here in Austin. We've got a huge animal shelter, and a lot of them
Yeah,
are,
and the other thing I would mention, because you mentioned Austin, um, Austin has its own FAP, its own jurisdiction. Austin, Dallas, Fort Worth, and Corpus Christi have their their own jurisdiction. We don't investigate any complaints at the state in those four cities, so they can have policies or statutes or ordinances that allow you to have a pit bull. They may be more liberal with their policies. when it comes to what type of, because of, Austin has the pet, a lot of animals that get adopted, so on and so forth. So there may be, it may be in line with their overall policy or how they're going about doing business. So that's a different, you got to look at that through a different prism. I think you have to look at that differently. But you'd have to know exactly what the Austin ordinance reads. But I think what David was talking specifically about from a state standpoint, as long as that emotional support animal, there's documentation that it supports a nexus related to the disability. I think you don't have much choice than allow that particular animal to be on the property, to be an ESA.
Okay, we've got two more really quick. So Chelsea Page, I see, can homeowners turn away pit bulls from tenant applicants if they're not ESAs? So if it's just a regular pet, you can put really whatever you want in your tenant selection policy, as long as it's not discriminating based on one of those 7 protected classes. So, you could say my tenant selection criteria, I rent to people with dogs, but not cats, because I, want to live back in my home after this rental period and I'm allergic to cats. Totally fine. So there you go on that one. And then let's do a last one. We have, what areas does the Texas Workforce Commission cover? So I assume this is in regard to what you just said about there being specific areas that you guys kind of do not touch because they have their own areas. So if you want to talk about that, Pat, really quick. And then Oscar, I see your question. I will go ahead and shoot you an email on that one. That one's a little tricky.
Yeah, there's 5 FAPs in the state of Texas. The Texas Workforce Commission is one. Dallas has its own FAP. FAPs are Fair Housing Assistance Program. So everything in the city limits of Dallas is done by that particular FAP. Same thing in Corpus Christi. Same thing in Austin, and the same thing in the city of Fort Worth. Everything out the rest of the state is the jurisdiction of the Texas Workforce Commission. So Amarillo, El Paso, East Texas, you name it. We're responsible for the rest of the state of Texas. So obviously it's a big jurisdiction.
All righty, y'all. Well, we are now at 3:47, so that concludes our time for today. We want to thank everybody for coming on today. Thank you so much. Have a happy holiday season. We will continue working with the Texas Workforce Commission. So if you guys have any questions or need any further information, there will be an email that goes out tomorrow with a follow-up. So look for that and I can point you in the right direction. Thanks so much, everyone.
Okay. No, thank you. Have a good day.
Bye-bye.
Thank you, everyone.